I think we'll get going, if that's okay with everybody. Just so everybody knows, I am recording the session today. So if you want to pass it on to anybody after and you think the information is fantastic that we're doing today, please feel free to pass it on. We will be sending it across to everybody once the session's finished today. And again, it'll be in our webinar library again on the Chamber's website. So good morning. I'd like to welcome you all to this morning's event, Brexit, the Domino Effect. And I'm delighted to introduce Stephen Hadley. We have some fantastic speakers this morning, so really excited. As I said, for those of you that didn't hear me when I first started talking, and Mike asked that great question this morning, if the speakers are talking and you have a question, please pop that in the chat area at the bottom and we will manage that as best as we possibly can. And then if you want to ask a question after they've done sort of their interview with Stephen, then you can raise your virtual hand, which you can do either at the bottom, should be the taskbar at the bottom of your screen, or sometimes it's also at the top of your screen as well. Brilliant. Brilliant. Stephen, it's over to you.
Thanks, Laura. Laura will be looking after all the technical side of this. Thankfully, that means that I don't have to. Just like to welcome you all to this finest webinar, particularly at this godforsaken time in the morning. I'm very definitely an owl, not a lark. One of the things I do appreciate is the fact that I don't have to do the commute in these rather strange days. For those of you who don't know me, I'm a partner in the dispute resolution department at Freeths. Many years ago, for my Canadian University master's thesis, I wrote a thesis called The European Court of Justice, Revolting Judicial Behaviour, which was rather prescient in the light of the way the argument developed over Brexit. And it's meant, of course, that I've always had an interest in EU law and looking at the wider picture of the relationship between the EU and Britain. We are now 3 months after Brexit. I think it's an appropriate time for us to take stock and find out what has actually been happening on the ground. Given that this is a professional services group, one of the things I'm finding is, in some ways, I'm not directly affected in the work that I do, but I have an awful lot of clients who are affected and are affected in different ways and having different issues. And I'm sure that's the same with most of the audience. And it may be that one of the things we can do today is talk about what our clients' experience is and what developments there are on the horizon. Just in my area, in the last couple of weeks, we do a lot of debt collection, and that includes in Europe. And there used to be an arrangement whereby the judgment of an English court would be very simple to enforce in Europe. Just last week, an English judgment in September, so before we left the EU, was registered in Switzerland after the 1st of January. And the Swiss court said that because we had joined that convention as a member of the EU rather than on our own account, and we were now no longer a member of the EU, they weren't going to give effect to that judgment. Now, it may be that that's followed in other courts throughout Europe. We just don't know at the moment, but that's an immediate impact on the people that we deal with cash flow for. In terms of the panel, we've got 3 great speakers for you, talking about tax, talking about cyber, and talking about logistics and export. We're going to have throw it open to the floor after each speaker, and then at the end for everybody to ask any questions they've got. Please feel free not just to ask questions, but to pass on information. As I said, I would quite like this to be interactive and learn about what's happening with your clients and your businesses. Just as a bit of a backup, I've got my colleague Lynn Ingram here, who's an employment lawyer, because that's one of the areas I know that people are having a few issues. That's pretty much everything I want to say to start with. So I'd now like to introduce Colin Woodward, or rather I'd like to allow him to introduce himself. He's a bit of an accountant's accountant. His was the name that came up when we asked people who would be good to do this on the tax side. All of the accountants said, oh, it's got to be Colin. And he tells me that an awful lot of his practice is acting as a consultant to accountants. So, Colin, do you just want to start off by telling us a bit about yourself and what you do?
Yes, it's perhaps first of all worth mentioning that whilst I'm a director of Barrington's, which is a firm of chartered accountants, I'm not myself an accountant. I'm actually a chartered tax advisor, and it is a different discipline. but I'm also a VAT practitioner, and I've been a VAT practitioner for over 20 years. VAT is a very international tax. There's over 160 countries in the world that have got some sort of value-added tax, and and with being an international tax, there's a very clear interaction between that and customs duties and customs work and movement of goods and indeed services, because of course we don't just import and export goods, we import and export services too. Most of my work, the vast majority, is outside of Barrington's, is with other firms of accountants and with businesses direct, as well as the tax investigation defence work. I do a lot of consultancy work, and certainly recently, particularly during December, starting December and into January, and ever since, it's been very much consultancy on the effects of Brexit, and really a lot of that has involved finding practical solutions to problems that people have had or people have encountered that they didn't appreciate or weren't particularly portrayed by HMRC or the government as being an issue before we actually left the transition period at the end of last year. And certainly they're quite diverse in the nature, and businesses are finding they're having to reconfigure how they do business in Europe. In some cases, this has involved structural changes to their business. In other ways, quite simple changes, but nevertheless necessary ones. And certainly one of the objectives of many suppliers from the UK of goods and services into Europe is to make things as easy as possible for their customers, because the margins on a lot of products are quite tight. And a simple administrative obligation is enough to deter EU customers from buying from a UK supplier. So this has involved, as I say, some structural changes, but certainly additional obligations and often additional costs for UK businesses to try and alleviate some of the consequences.
Okay, Mike. Colin, I think from my point of view, what I'm hearing in the press is a lot of instances of double taxation and a lot of chapter about rules of origin. Do you want to talk a bit about that and about what circumstances double taxation comes in? Yeah. The free trade agreement, which was trumpeted by the government just before Christmas, has been the best thing since sliced bread, is okay to an extent, but it only applies to goods that have originating status. So goods entering the UK from the EU can be free of import duties, not import VAT, provided that they have originating status in the European Union, and vice versa. Goods entering the EU from the UK can benefit from tariff-free movement, providing they originate in the UK. But a lot of goods don't have that originating status, and a common example is where an importer of goods into the UK has previously acted as an EU distributor. So, for example, clothing from Bangladesh, which generally has a duty rate of around 12%, the duty will be payable once the goods enter the UK. Now, previously, we were within the customs territory of the European Union, so we'd have unfettered access to the European market. But if those goods are now sent into the European country, then the 12% rate, which also applies in the European Union, is triggered. And therefore, we have, in effect, a double duty. And this has led to some businesses finding they're having to restructure and have an actual, sometimes an entity or sometimes a presence, and sometimes, in some cases, no more than a VAT registration number on the European mainland in order to avoid the double duty cost. It's obviously involved extra costs, but it's logistically essential for this type of business, because 12% is obviously a significant erosion of a margin. So you can actually have a VAT registration number in the EU without actually having a presence there. Do you have to have one in every country, or is one in France enough for the rest of the EU?
It all depends where you're importing into. There's nothing that new about this. Those who sell via Amazon using Fulfilled by Amazon will have come across this before, because if you have goods located in the European Union and supply them at that point, as in, for example, an Amazon warehouse, where Amazon fulfill your orders from stocks they hold, you've got an automatic and immediate obligation to register for VAT in such countries anyway. This is more, rather than an obligation, it's a necessity. But it's also compulsory as well when the conditions arise. So if you import goods into the Netherlands from the Middle East, which is quite a popular destination, it's logistically good, then you would need a VAT registration in order to trade from there. And of course, you would incur import VAT when the goods arrive, as well as the duty, which you want to recover. Well, basically, as soon as you trade somewhere, you've got to register. Sometimes you can, I mean, a lot of what I do is aimed at minimising people's pain. So if we do need multiple VAT registration, it's getting as few of them as possible as we can get away with. And get away with one, that's great, but that's not always possible.
Are you finding that many organisations, either into Europe or the other way, are just deciding, at least for the moment, it's not worth the hassle? And the other thing, I suppose, is are there any specific issues coming out of Northern Ireland, given that that is in even more of a flux than the rest of the EU?
Yes, indeed, yes. Certainly, I've had instances of businesses where the majority of the trade is in the UK and the minority is in the EU, just deciding to shut off that type of business, at least until things improve, which they might do. I mean, it's possible that there will be tweaks to what we've got at the moment. With regard to Northern Ireland, it's surprising how often I get asked questions concerning Northern Ireland. Even though it's a very small part of the UK, it's very significantly impacted by all of this. It's got a foot in the EU and a foot in the UK. There's a notional customs border the GB mainland on Northern Ireland, and there are special rules for trading with Northern Ireland, which affect everybody, from e-commerce traders down to second-hand car dealers, who were particularly hard hit until the government backtracked on some of the rules. But yes, Northern Ireland, I do have an accountant contacted to do some work within Northern Ireland. I was speaking to him only yesterday, and he's finding that he's got clients who businesses on the UK mainland simply don't want to deal with anymore because of the hassle involved with getting the goods into Northern Ireland and having additional checks which weren't there before. And it's not just duty. There's no customs duty arising between the UK and Northern Ireland in most instances. One of the biggest factors of Brexit is the hassle factor. It's having to, every movement has two legs. It's got an export to one jurisdiction and an import to the other. So there's two sets of documentation that will be prepared by somebody. And that brings with it the obligation in many instances for import taxes, but it's the actual getting it done. There does seem to be a shortage of customs agents out there able to do this. That's the other part of it.
What are the sort of the main solutions that you're advising on? Is it set up somewhere? Is it don't do it? Is it register for VAT?
I never tell anybody not to do it. You know, I always try and find a solution for the clients who go out of business. But I always try and find a solution with it. But I think perhaps something worth mentioning is triangle transactions, which are immensely common in the European Union. This is where a business in the UK, whilst we were part of the EU, would buy goods from a supplier in France and have them delivered directly to Italy, to their customer in Italy. So the UK would have a supplier in France and a customer in Italy. Under the basic European rules, this would necessitate the UK business having to register for VAT in either France or Italy. But there is a simplification available to European businesses which avoids that, the so-called Article 28 simplification, which means that this trade can go on without the UK intermediate business having to register for VAT. Now we're not part of the EU, we've no longer got that available. It's surprising how many businesses there are whose entire business seems to comprise buying from one EU member state and delivering to a different one. And actually, this is a situation where we can have a VAT registration in a single member state and take advantage of the simplification. And Ireland is obviously a popular choice. Certainly it's the one I tended to register people in when they've had this type of situation, because the revenue authorities are quite helpful. And of course, you know, we've got a commonality in language. So sometimes it's quite a simple solution to, you know, a significant business issue. But the problem that you sometimes have is until people don't realise this is a problem, until suddenly they've been charged French VAT and wonder how on earth they can get it back. And you know, that can be tricky, because sometimes we're looking at things in retrospect.
And of course, you're dealing with France, or perhaps I shouldn't say that.
Probably.
That's a very quick whistle-stop tour through the main issues. I just wonder if there's anybody in the audience who's either got any particular problems about that, or has got any particular experiences, good or bad. Has it been not as bad as you thought, or has it been easier?
They've all gone home.
Far too early in the morning. You mentioned the word VAT in a regulation. That's enough.
Probably, it does frighten people up. Just one other point perhaps worth mentioning is that from the 1st of July this year, the EU are overhauling some quite significant parts of their VAT rules, as they will apply to non-EU businesses trading within the European territory. So we've got that to look forward to. I'm just getting to grips with that at the moment. And one other point which HMRC rather sneaked in late last year was who has the right to recover import VAT in the UK. It sounds perhaps slightly obscure in this context, but a lot of, if a UK supplier supplies equipment to a European customer, that equipment has to come back into the UK for repair or servicing, then that's an area where businesses can get caught up and trapped into reclaiming import VAT, which they're not entitled to. Because the only person who can reclaim import VAT is the owner of the goods, and the goods are in overseas ownership. So this is another area I'm finding happens quite often. There are ways around it, but they're quite bureaucratic and time consuming. So somebody who's got a significant amount of this type of business needs to really get the available customs and VAT reliefs in place as soon as possible.
Okay, thanks for that, Colin. I think we'll now move on to Steve Sands, who is the Cyber Risk and Compliance Officer for Synectic Solutions. Steve, are you with us?
Hi, yes, how are you? Can you hear me okay?
Yeah, now we also appear to have got your presentation slides on screen. So I think if you just want to give yourself a brief introduction and explain who you are and what you do.
Yeah, sure. Hi. So I'm Steve Sands. I'm the Chief Information Security Officer, and for my sins, the Data Protection Officer at Synectic Solutions. Mainly involved in internal practitioner work, if you like. So looking at the new data protection legislation and interpreting it for the business, but increasingly that involves providing advice and guidance to our clients as well. For those of you who know Synectic Solutions, we're pretty closely tied up with Port Vale and the Hub Foundation these days too. So I find myself on calls with people at the Hub Foundation working out how we process the likes of children's data for some of the events that they run. So all sorts of things that a few years ago I would never have imagined being involved with, but it makes for interesting times, doesn't it?
Absolutely.
So Synectic Solutions is primarily a data processing organization. Like any business, we're a data controller for our own data, but mostly we're processing data for other organizations. And most of that is around the fraud prevention type space, providing services to financial services sector organizations and indeed to government. So I thought I might just rattle through a couple of slides, which I'm hoping will set out a couple of scenarios that may be familiar to the audience today and could indeed prompt a few questions that people have either already thought of or perhaps ought to be thinking of. So just a single slide on the relevant legislation and a couple of key terms. So there's the GDPR. Everybody knows about the GDPR. The GDPR it is a piece of European legislation, but of course, since Brexit, we have adopted the GDPR into the UK. It's a slightly different version to the EU version, but if you're familiar with the EU version, there's not a great deal of difference to it. The UK GDPR is implemented through the Data Protection Act 2018, which replaces the old Data Protection Act of 1998 that sat around on the shelf gathering dust for many, many years. People tended to in many cases tended to pay it lip service, so it was a bit of a box ticking exercise. The whole point of GDPR is that the intention of it is to provide much more accountability to organizations who process other people's data. And of course, the third one there is the European Union Future Relationships Act, and that implements the Trade and Cooperation Agreement. I'm no expert on this, but I think that that provisionally applies until April 2021. So that's the end of next month. Key terms here: data controller. Data controllers are an organization that makes decisions about data, so makes decisions about the purposes, the uses of, and the technology to some extent involved in processing data. Data processor acts on behalf of a data controller. So in most cases, we're a data processor and we're acting on the instruction of our clients. And processing pretty much anything that you do with a piece of data, from the point at which you collect it to the point at which you get rid of it. So what's changed since Brexit? Well, as you all know, I think our status has changed. We have become what's known as a third country. So we're sitting outside the EU and the EEA. So that's all of the 26 member states, plus Iceland, Norway, and Liechtenstein. And currently, we're not recognized as adequate under the GDPR. And in simple terms, that means that essentially we're not trusted by the European Union in terms of the adequacy of our privacy arrangements. We're hoping that we can change that fairly quickly, but at the moment, in theory, it makes EU to UK transfers of data a bit more difficult. In fact, the European Data Protection Board have invented a 6-step process that anyone in the EU should be using when they transfer data to anyone outside the EU who hasn't been deemed adequate. Now, the good news is that they established a bridge period. That's 4 months, which can be extended to 6. And that is really just to give us all time to establish this adequacy status, which means the EU will deem the UK to be and have an adequate privacy framework, which means that those bits of data can flow freely backwards and forwards between the UK and the EU in both directions. So that's the key part, in both directions. So there's a few scenarios here. If you're based in the UK, your data subjects are in the UK, you're processing data in the UK, you've got nothing to worry about, nothing changes. You simply have to comply with the new UK GDPR, which is enshrined in the Data Protection Act 2018. Slightly different if you're based in the UK and your data subjects are in the UK, but you're processing your data somewhere in the EU, but still fairly straightforward. And it's straightforward because the UK has recognized the EU as being adequate. So any data transfers from the UK to the EU are absolutely fine. They're already covered by that adequacy, which goes in one direction from the UK to the EU. Coming in the other direction, currently no change because of this 4 to 6 month bridge period, and awaiting that adequacy decision. Once we get that adequacy decision, then in fact, there won't really be any change to what we have been used to whilst we were members of the EU. GDPR took effect and through that transition period. However, if we're not granted adequacy, which I have to say is unlikely at this moment in time, then there are other things that you're going to have to consider. And to some extent, that depends on just how far down the line you want to go, how much accountability you want to take for what you're doing, and how closely you want to follow all the guidance. The UK Information Commissioner's Office is pretty much replicating everything that comes out of the European Data Protection Board right now. So we're very closely aligned to them, which is why I think that the adequacy decision, which has already been drafted and is going through the process for approval, I think that will become a matter of fact in a very short time. However, in fact, one of the questions I think Charlie Houston Brown has asked is about the possible divergence of the UK and the EU in terms of the way we approach data protection. So that adequacy decision, when it comes, my understanding is it will be time limited. And that will mean that they will probably set something like 3 or 4 years for it, after which it will be reviewed and could be revoked. And if it's revoked, then the game changes really, because if we need to do processing in the EU, or indeed process data for anyone based in the EU, then we will need additional safeguards in place, or the EU will require additional safeguards, because they will see the UK as a completely different entity, a third country, which is no longer trusted and has that adequacy decision or adequacy safeguard. So the simple way around that, the one that everybody talks about, is using something called standard contractual clauses. Standard contractual clauses have been around for a very long time. They work for controller to controller transfers, or indeed controller to processor transfers. Because they've been around for a very long time, they actually don't match in very well with the GDPR. So the bad news is that they're about to change as well. And we can expect that by the end of the year, if you're already relying on standard contractual clauses, you're probably going to have to update them all probably towards the end of this year. So what else? If you're UK based, but you've got establishments in the EU, you process data about EU citizens, you may very well need a data protection representative based in the EU who can cooperate with the EU supervisory authorities. So that's the equivalent of the Information Commissioner's Office in whatever country you are established and doing most of your work in. And you're absolutely going to have to fully comply with the EU version of the GDPR. That's alongside all the usual stuff, of course. So you need still a legal basis for your processing. You need your fair processing notices. If you're doing any risky processing, you need some data protection impact assessments. You need to maintain records of processing activity, do all the security stuff, and so on and so forth. So that's kind of a whistle-stop tour of where that's at. The final point on the last slide, I think, is the 6-step guidance that came out of the European Data Protection Board, which means that if you're in the EU or the EEA and you're transferring data out to a third country, so should the UK become a third country now or in the future, they're going to have to look very carefully at those transfers. You're going to have to understand your transfers. You're going to verify the tools that you're using, the mechanisms, whether you're relying on standard contractual clauses or binding corporate rules or something else. But there's more to it than that. They will assess very carefully the privacy rules and regulations of the third country that you're transferring into. And this is an interesting thing, because the US had a system called Safe Harbor, which changed into the Privacy Shield, which has recently been invalidated. So when you were transferring data to the US until recently, if you were transferring it to an organization which was covered by the Privacy Shield, then you were in a pretty strong place. That's recently been invalidated, which means that the US is now a third country, and that you are expected to go through these 6 steps for any transfers that you make to the US. So it's a very moving feast at the moment. It's a little bit like trying to pin a jelly to the wall, I think, at the moment. And again, that whole business of whether the UK diverges from GDPR or sticks with it, a bit of a political question. If I had a crystal ball, I would say we're going to stick with it. I would say that we're going to remain linked into GDPR, because in my view, that's the way the world is going. I think more countries are adopting GDPR-like regulations to govern their data transfer and privacy. I think less of them are moving away from it, but it's a great question that was posed by Charlie.
Okay, just a couple of quick things, Steve. So what it seems to be the case is we actually have the possibility of yet another Brexit cliff edge at the end of June in relation to adequacy. Now, a bit like the deal itself, everybody expects that at the very last moment, if not slightly before, there will be a deal. How big a cliff edge is it if it doesn't happen?
Okay, I mean, frankly, it's not a massive cliff edge for those people who who are already thinking about these things. I mean, the key thing is know in advance what data you have and where you process it and where you transfer it. So if you haven't done that work up front, now's the time to do it rather than wait to the last minute. From a risk perspective, it'll probably all go wrong for you if someone complains and the ICO or the European Union starts getting wind of something going wrong, which triggers them to investigate whether you are complying with the relevant bits of legislation. But if you know all of your transfers and you have either already implemented one of the adequacy mechanisms, so that's binding corporate rules, which in reality are only used by the largest organizations. Most organizations that are doing these things are thinking in terms of standard contractual clauses. If you've got those in place, you're in a healthy place. You're in a good place. If we head for that cliff edge, then be prepared to wheel them out fairly quickly. There's some really great advice on the ICO's website, and actually there's a little tool on there that enables you to go in and rattle through some questions, a questionnaire an online questionnaire, and create a version of the standard contractual clauses that work for you. So it's not a difficult thing to do, but they're very, very prescriptive. You have to use them exactly as they're laid out, and then they have to be executed by both parties.
Okay. In terms of the US Privacy Shield, as I understand it, this question mark around it in the EU has come about as part of the global tension and battle, if you like, between national governments and the big tech companies. In this case, I think it was Facebook. So it's another front on the battle with the tech giants, but of course it's also to do with the US. In terms of the UK being seen to be different from Europe, do you think it will follow the EU and take on the tech giants, or do you think it's now in a position where that's where an element of divergence is likely?
Again, my hunch is that we'll follow the EU simply because that's where most of our data is flowing backwards and forwards, and we will want to remain friends with them from an adequacy perspective. So that's my best guess, but I'm not really a political pundit, so who knows? I would be very interested in other people's opinions on that one.
Okay. Laura, could you log in Charlie Houston Brown? Charlie gave us quite a detailed question about some of the issues we've been talking about. And if Charlie is there, firstly, I'd like to say, ask if we've answered your question or if you'd like to do a follow-up. But I'm also interested in why you've raised this question. Is it something you're coming across in your business quite a lot? What prompted it? Is it an issue for you or your clients?
Yeah, thanks, guys, and thanks. That was really comprehensive, Steve. Yeah, I think I see the adequacy issue very much like Steve. I think it's likely to be a nod this time around. I'm more concerned, and my clients are more concerned about the Privacy Shield issue, I think, because currently that ruling was done by the ECJ, and of course, politics being politics, could be overturned in the UK. So I think there will be a very fine line that's balanced by the UK government going forward to try and placate USA intentions versus EU intentions. A lot of small businesses particularly are using third-party tools which are hosted in the US. Okay. And so SME businesses, particularly in Staffordshire and of course in the UK, as they're using those software as a service type services from websites, landing pages, that kind of thing, really funnels, sales funnels, all that data really resides in the US. So I see that as the bigger challenge, frankly. I think the adequacy decision might hinge more on that in the future, rather than links with the EU, because there's no reason to diverge from GDPR, but there is a reason to diverge from the ECJ ruling of the inadequacy of Privacy Shield. But like Steve said, it's currently all up in the air. The DCMS have kind of suggested that when the ICO replace, I forget the lady's name now, but when she leaves the ICO, the head of the ICO in October, they're going to look for a more relaxed view potentially. So I think it's going to be a bit of a bumpy ride, I think, into 2022. But as Steve suggested, I think it's probably fairly calm for now. It's fairly stable, but I think it's going to run for a bit. But thank you very much. That's been very interesting. Thank you.
Okay, thank you, Steve. What we'd like to do now is to move on to Andrew Hipgrave. Andrew's worked in logistics and international trade all his life. He's worked all over the world, and he's now heavily associated with the chamber. And Andrew, would you just like to introduce yourself and tell us a bit about what you do and what's happening on Brexit from your perspective?
Absolutely. Yeah, my name's Andy Hipgrave. Currently based in Birmingham Chamber, but I work with international trade advisors from all 6 chambers within the West Midlands area. And primarily I'm seen as the service sector specialist, but through my previous experience, I've been doing global logistics, air, sea, land, work with all the carriers, etc. for 20 years now. So even though my label is service sector specialist, because of Brexit, I have been probably used as a resource more than anything else to help companies with whatever the issue, whether it be manufacturing or service sector issues. And I actually would back at what Colin has said, in that I've got practical experience of where things have gone wrong, or they don't know the new rules. So, for example, needing an EORI number and a VAT number in country. And because I work with other versions of the DIT, for example, in France, which is called France du Nord, I am able to help a lot of companies who want to set up in various countries within the EU, if it's necessary for their business. And I know that's a political hot potato because the government were against us, and I'm not allowed to give advice. I can only signpost. But a lot of your companies, or the companies that you work with, potentially could use that. And to add some credence to what Colin said, I have an example where an Italian company bought mudguards for lorries from an English company who wanted them then delivered into Holland. Sounds pretty simple, and it would have been before Brexit. Unfortunately, when they tried to deliver them, the Italians didn't want to do any of the paperwork because they think we've got a free trade agreement. A lot of the companies in the EU think that nothing has changed and they don't have to do anything else. They don't see the UK as being a third country, at least within the business community there. So it can cause major issues. So on import, the invoices were wrong, the origin was wrong, and the Italian company said to the English company, I'm sorry, but if we have to do any more than just order from you, we don't want to do any of the paperwork. That's all your responsibility. We just want you to deliver it. We've already sold it. We bought it from you, but we've sold it. We want you to deliver it to the customer. And if you can't do that, then we'll just buy from Germany. Even though Germany is more expensive, by the time all of this extra, and I think it is fuss, they just cannot be bothered to do the paperwork because there is a lot of it. Either that, or they don't understand what they have to do, which is ignorance is bliss for a lot of the companies there. Then that's a perfect example of why companies in the UK potentially could lose out for no fault of their own. Even if they're able to take the extra duty or VAT that might be due, they still can't get around the fact that they'll still have to do the administration for those companies that are buying the goods from them. And then another point that Colin brought up there about origins. I have a client that brings in goods from Ecuador. They're actually crisps, plantain crisps. Origin obviously is Ecuador, and they're bought into the UK, no problem. They're now obviously growing and they're doing particularly well. But as they sell their goods into both France, Italy, and Germany in particular, they now have an issue. And I can actually add to this in that they have an issue with marking, because does it need the new CE markings? And as the goods are already packaged in Ecuador before they come, that's an issue, because their shelf life is normally 6 months. So they have an issue with that. And they also have an issue because they import it into the UK first and then obviously export it then to Germany. So that has meant extra issues for them. So I would, there's two prime examples of carrying on from what Colin has said, where the companies really that you're dealing with need to be careful what they do and know what they're doing. There is help available. That's my big statement of the day. If they need help, i.e. setting up in Europe, if they need EORI numbers, VAT numbers, bank accounts, representation. Representation is a key one that's coming up quite a lot, because it's been in the press quite a lot, about having a representative within the EU for goods sent there. And it's proving difficult for some companies, depending on what industry they're in. So again, that could be an area where they can use the hub here, or use DIT, France du Nord, or indeed any other country in the EU. So from my point of view, my answers are very varied, because I'm not only dealing with manufacturers sending goods there, but also services going there. And service sales, I mean, from my own point of view, the opportunity for business and professional services is really good at the moment, with so many things coming up. We have the Rugby World Cup in France. We have in France also the Olympics are coming up. And then more worldwide, obviously, you've got Dubai with the giga cities there, the mega cities. We've got new free trade agreements with Mexico and Colombia. And I know there's a lot of business being done there, particularly in the automotive industry. So the opportunities for BPFS is really big, and it remains the same. I think in the West Midlands area alone, 71% of GDPR for the area comes from services. So from that point of view, it's a positive note. But I think it's a little more complex now. The waters have been muddied by obviously the new legislations and the help that's needed. I do think companies, to an extent, are giving up for the time being on working with Europe, particularly in a manufacturing point of view, because of the double taxation, or they don't know a way around the double taxation. And I think that's just out of ignorance. I think that the message should be get in touch with one of you guys or ourselves to try and get some expert opinion on the company first, to make sure that you're not being double taxed, or that you're doing the most efficient way of actually delivering your goods to market. So that would be my message to any of you guys there.
That it struck me as particularly interesting that what you're getting is you're suggesting that the EU or business in the EU was even less prepared for Brexit than we were. And what they're now doing is they're now saying, actually, this is not our problem, it's your problem. So UK companies are not only having to deal with their own issues arising out of Brexit, but being forced to address the EU issues coming the other way. Otherwise, companies in the EU won't deal with them. So it's almost like a double whammy of we're having to do both sides.
I'd absolutely agree with that. In my own personal experience of companies that I've helped, that is true. And I think within the EU, I think that it's a golden one that I think once those companies thought we've got an agreement, that things remain the same. And clearly, the concept of a third country hasn't sunk in yet. So now they realise that there's a lot more documentation that they need to do. They're certainly walking away from that. And that, I mean, the example of the mudguards happened 10 days ago, and I'm still helping that company directly. But that scenario where an Italian company's bought the goods from here, sold them to a Dutch company, and think that it was going to be exactly the same process as it had been on the previous order, which happened before Brexit. And now they're saying, well, oh, if that's the case, the English supplier is saying you need to do these forms and you need to put your number and your VAT number on there, because you're the one that's due to pay the tax and then claim it back, because you're both in the EU and you've sold it. So the ownership is yours. they're not prepared to do that. So that what they said was, well, if you do all of that, we'll still buy from you. If you're not willing to do that, we'll buy from a company in Germany and do it that way. And then he's cut out of it. And to be fair to the company, mudguards is not the only automotive thing that he makes. So it's his whole business that's on the line here, or his whole European business that's on the line here. So it really is a case of ignorance with a lot of companies in Europe. And that's something that you need to make your clients aware of, in that what they think might be telling them as the truth, as gospel, is not actually the facts of the matter. They're just being lazy and don't want any extra hassle.
Okay. You're a bit of a resource. What can you offer to the people in this audience and also to their clients? What is the practical things that you can do for them and help them with?
The practical things are really like, for example, making sure they've got the right documentation when they're sending things abroad. If they don't have, there's a documentation actual department in the Birmingham Chamber where they can go for help with any documents of anything that needs to be exported or even imported. They'll help with that. So if it's practical help, you've got that exportation there. If there are any individual issues, particularly because I've been dealing with a lot of gold bullion, believe it or not, I can help directly when I'm saying being used as a resource for actual how it should be sent, what's the fastest way, which is the best line haul, security, or it could in some circumstances even be intellectual property. How do they protect themselves from that? Because there's a lot of cyber security that we provide as well. So it's multifaceted. So each is individual depending on the industry that they're in. But obviously you can come to us for some honest advice, or even maybe signposting in some cases to at least put you in the right direction as to how to export those goods and what's liable. I mean, Colin was obviously very useful there. What's liable tax and VAT duties? A lot of that is really important and has changed. So that's something that they really need to be aware of.
And on the other side, we've now left the European Union. Has that actually opened up any opportunities from your perspective for the rest of the world, or is that still a bit too early to say?
No, it absolutely has opened up a lot of opportunity, because the governments obviously are politically under pressure. And if we're not dealing with the EU, then who are we dealing with? And so that's led to free trade agreements with Colombia, Canada, Mexico, Japan. Japan is particularly strong in BPFS services. So that's quite a good one. But Canada are really keen to do business with us. Then we've got the Transatlantic Chamber, which is based in Birmingham, which is directly linked to the American judiciary there. So that's really good from that point of view. And there are all kinds of connections there that's possible. And also, obviously, the Commonwealth. Is, with the Commonwealth Games coming up, there's been a big push recently with all the Commonwealth countries, and those doors are open for business. And as I said earlier, to back it up, I mean, if you think about what's happening in France shortly with the Rugby World Cup, with the Olympics, which is a huge thing, and that they're actually planning all of that now, and there are tenders out there for business currently. And then obviously you've got Dubai with the mega cities there, huge amounts of business being done there. And then we've got new agreements with the likes of Indonesia and Thailand. I mean, there's a lot of in-post things that I think, because we've dealt with the EU and it's been relatively easy to do that, that's been fine. But I don't think people have looked any further than that because of potentially translation issues or whatever that might be. But now those doors seem to be closing a little. It's forced our hand to look at the other opportunities, and the other opportunities are very good. So they're equally as good as the EU ones were before. Given how much business we did within the EU prior to Brexit, there's no reason why those countries can't actually take the place of that business. And I would encourage all of your members to look at all of those countries that I've mentioned, because there are lots of webinars on the DIT website, etc., that are recorded that you can go back and watch again, where you can see who you can actually be added to the list of potential clients for companies to look for. And I know that's happening a lot with Dubai at the moment. They are looking for expertise. So there's a lot of construction companies within the UK that don't have legal representation, for example, when dealing with Dubai. And it could be something as simple as invoicing, or it could be fintech. It could be anything really from the service sector, but there's definite opportunity there. It's a case of making yourselves aware of it as much as you can.
Okay. Right, that's finished with the speakers for the moment. And what I'd like to do now is throw it open to the floor for any particular questions you've got for anybody here, or any comments that you've got, or any experiences that you've had that might help anybody else in the room.
Mike, your virtual hand is up.
It is indeed. I'll put my virtual hand down. Lots of great information there, guys. It's really, really interesting. I'd like to turn it completely on its head, if I may, and I would like, Colin, if I could ask you a direct question to, I've got an assumption, and I'd like you to tell me, please, whether my assumption is correct. Obviously, we've got clients that deal internationally and so on, but we also have people, a bit like me, who only deal within the UK at the moment, who are VAT registered. My assumption, therefore, is because I don't do any international stuff, nothing changes for me VAT-wise. Is that a correct assumption?
What's the nature of your business?
Yeah, it's professional service training, coaching, and things like that. So at the moment, it's just UK based. So I'm working on the assumption nothing changes for me with regard to VAT. Is that a false assumption?
Your assumption is correct.
Good. So if anybody asks me, oh, does that apply to me? I can say no. For the moment, VAT stays exactly the same.
Yeah. It might get relevant if you start having overseas clients, but there certainly have been changes to the overseas services, but not to the extent that they've affected goods, and certainly goods have been far more impacted. But there have been some changes, but certainly as long as you're trading within the UK, it's not going to be an issue for you.
Great. Lovely. Thank you for removing my assumption with the answer that I was hoping for.
Okay.
Brill, has anybody got any more questions? You can raise your virtual hand, or you don't have to. You can just sort of.
Can I just, if we've got no other questions, can I just bring Lynn in? Lynn, from an employment point of view, what are the questions that you're being asked by our clients? You're looking for Lynn Ingram, Laura.
Yeah, I'm here. Everybody hear me? Wave if you nod. Yeah, good. There's a couple of things really, Steve, is we're picking up on there's been where should we start? So the EU citizens that were here before transition, they were allowed to remain. There's something that they have to do by June this week. It's a registration. Majority of the EU citizens have done this. It does involve disclosure of criminal records and things like that. So a lot of perhaps the manufacturing sector I work with, where they're going through and redoing their right to work checks, the people who aren't supplying the new information perhaps are the trouble ones. There might be something that's there. So the first thing I'd be saying, I say I'm an immigration lawyer, I'm an employment lawyer, not an immigration lawyer, but there is an overlap, is get the right to work checks in for your EU citizens. I think on a more sort of macro economic point of view is that there's been a bit of an exodus, especially of the Baltic and the Eastern European migrants that came to the UK because it was really favourable to come to the UK. And when the borders opened up back in 2000 and whenever it was, other countries in the UK put restrictions on. The UK didn't. There were, I think, after Brexit they started to leave. It was less appealing to be here. But last year, 200k Eastern Europeans left. So there's probably might be a little bit of problems with recruitment for certain sectors as well, and that will obviously push salaries up. So that's something to bear in mind. And another it's probably a double whammy with Brexit and with COVID hitting as well that I'm picking up on is people who are working from home are thinking, well, I can work from anywhere then. And we're getting lots of individuals who are hoping to be able to work outside of the UK, if they've got holiday homes or if they've got residences outside the UK for part of the year as well. So we're picking up things with regards to that, and that's obviously a big data issue, which you know that we need to challenge. But those are some of the things I'm picking up at the moment, the queries that are coming in.
Okay, thanks for that, Lynn. Has anybody else got any more questions? No,
I don't have any. Sorry, I don't have any more questions, and I cannot find the raise hand thing on my screen whatsoever. I just wanted to say thank you so much to the speakers. That has given me. Brexit, I don't know about it. I'm a big novice to it, and I work at Hanley Economic, and we have a lot of data in the UK. Obviously, most of our customers are UK based, but we do have some expats, etc., that we have mortgages with, for instance. So data handling and all that sort of stuff. It's been with me being in the marketing team, it's been something I've had to sort of deal with. We're not trading at the moment with mortgages, so it's kind of something that's off the table right now. But it was really, really helpful, and that was incredibly useful. So thank you. I just want to say thank you for that. Really interesting.
Okay, well, I think all that remains for me to do is to firstly mention that on the Freeth's website, there is a thing called the Brexit Hub, where we have a number of videos of various talks that we gave on a Brexit week about 2 weeks ago, plus also a number of resources about where to start thinking about the legal implications of Brexit over the whole gamut of legal things. And what I'll try and do with Laura afterwards is maybe circulate that website address. And then it's thank you very much all to you all for coming, to the speakers for putting their time in, and for Laura to making sure that it ran reasonably well. I'm sure you're all very busy, and if you need to get off and go do other things, feel free. If you'd like to stay and have a chat with those people who are on, ask any follow-up questions or just network, feel free to do that as well. Thank you very much.
Well, sorry, before you all go on, apologies. I just want to grab that the next finest event is the 29th of April, and it is a networking event. So please come. It'll be really exciting to have you here. I'm sorry, just thought I'd put that in before we all go. And like Steve says, you're happy to stay on the call if you want to. If not, it's been an absolute pleasure today. So thank you very much.